Well, good afternoon, everybody, and welcome. And thank you for joining us for today's Effectively Managing Employee Performance and Conduct Tips and Strategies for Employers, a Labor, Employment, and Human Rights webinar. While I introduce myself and my speakers, please see the information on the slide in front of you. Just very quickly, my name is Matt Link. I'm a partner in the Labor and Employment group here in Fasken's Toronto office, and it's my sincere pleasure to be presenting this webinar along with my colleagues. First of all, Nicole Singh, who is a partner in Fasken's Toronto office. Nicole regularly advises public and private sector employers on a wide range of issues, including labor disputes, grievance arbitrations, human rights accommodations, employment standards, collective agreements, and other matters. And special guest panelist from out of province, Amélya Garcia, who is associate in our Montreal office. Amélya advises and represents clients in various aspects of employment law, including collective and individual labor relations, represents employers in cases involving grievance arbitration, interpretation of collective agreements, and various labor standards and contract drafting matters. Now, with that background out of the way, on to our presentation. We've got a power-packed agenda for you today when it comes to the issue of performance management, managing the conduct of employees, and progressive discipline. So here's just a brief outline of the agenda. We'll start with reviewing the concept of performance management and then talk about the concept of the performance improvement plan as part of the performance management process. We'll then talk about the purpose and the importance of progressive discipline, when and how to implement progressive discipline, talk about some non-disciplinary strategies for addressing poor employee performance, and touch on other considerations when you're taking disciplinary action. Amélya will provide a special highlight with respect to employers located in Quebec in terms of the considerations that they should take into account. And then we'll wrap things up with a review of performance management in the remote and hybrid work environment, starting with the do's and don'ts of a remote work policy, and finishing up with a discussion of the shift that performance management has taken with the move to remote or hybrid work environments. And with that, I'll turn it over to Amélya to talk about performance management and performance improvement plans.
Yes, thank you, Matt. So we'll start by discussing performance in the workplace, and more specifically, performance management and performance improvement plan. So the importance of performance management. It is really one of the most common and most difficult issues facing employers. Nobody likes to give bad news. No one wants to feel like they are underperforming or that someone is always looking over their shoulder. It can certainly have an impact on productivity, and not only because of the employee who is underperforming, but also for the person in charge of managing the performance. It adds up to their usual task, and even on the other employees who may have to make up for what is not done by one of their colleagues. It is vital that employers implement and follow a consistent and effective performance management system. Performance management can apply to a number of different issues. We can think about, for example, what employee work input. It can be the quantity or the quality. It can be the fact that an employee work is consistently behind schedule. Maybe an employee who is unable to maintain satisfactory working relationship with his manager, with his colleagues. An employee who is late, absent frequently. So all of these issues can entail a performance management process. While managing performance, employers have the right to expect a certain level of performance. They have the right to establish reasonable standards of performance. They have the right to expect that employees will perform their assigned duties in a careful manner. They also have the right to expect that employees will generally exhibit a positive attitude and work habits. And finally, the most important one, I think, is that the employers have the right to impose discipline when employees fail to meet standards of performance because of culpable conduct. So a key distinction must be made and must be drawn between culpable conduct and non-culpable poor performance. Culpable poor performance is the inability to fulfill the requirements because of factors that are within the control of the employee. We can think about an employee who just doesn't care, who has a disregard for procedure, who has a poor attitude, who is inattentive, while non-culpable poor performance is the inability to fulfill requirements because of factors that are beyond the control of the employee. So we can think about an employee who maybe has a physical or mental disability and is unable to perform efficiently the work that is provided to him. You have to keep in mind that an employer cannot discipline an employee if poor performance is the result of non-culpable behavior on the part of the employee. And it is also important to note that if the poor performance is the result of a physical or mental disability, for example, or any other protected grounds, the duty to accommodate under human rights legislation is triggered and must be met by the employer until undue hardship. Finally, to terminate an employee for poor performance, it must generally be both serious and willful. And we are normally looking at a performance that is rising to the level of incompetence. Next slide, please. So the test for assessing the qualification and capabilities to perform a job is one of reasonableness. What we are looking at is that we are not looking at perfection. An employer cannot insist on perfection in every respect of every duty assigned. Employees will make mistakes from time to time. So we are really looking at whether it is reasonable. The overall goal in managing performance should really be in order for the employee to improve his performance. The goal is to fix the relationship between the employee and the employer, and we want to make them a productive, a valued, and a contributing member of the workforce. So the goal should not be to discipline firstly. And while managing performance, the employer will need to rely on their frontline managers and supervisor, as they are the ones that probably deals with your employees on a day-to-day basis. It will also require the support of senior management and human resources. And finally, the most important bullet point on this slide is communication is key. Leaving issues unspoken or unclear is not going to be of any assistance in the process. So we'll now talk briefly about performance feedback and reviews. So you do not want to wait until the annual or semi-annual formal performance review before raising issues with your employees. You want to address them when they arise. However, be sure to take advantage of the formal performance review if you haven't raised the issues with the employee before, or just as a means of reinforcing it. And moreover, during performance review, always be specific, frank, and thorough. At the same time, do provide constructive feedback to your employees and ways for them to improve. As we've mentioned before, the goal is really to fix the relationship. Next slide, please. We will now briefly discuss about the options that an employer have while managing performance. So there are a number of different ways to manage employees' performance. Termination is not the only option. Depending on the situation, these options may include placing the employee on a performance improvement plan, which I will discuss in a few moments. You can implement progressive disciplines, which, and my colleagues, Matt and Nicole, will briefly discuss progressive discipline with you later on. In some cases, maybe a demotion can be appropriate. For example, it is possible that an employee may be a strong performer in a different role, and they have simply been given work that are above their pay grade or work that requires more knowledge or skill that the employee has. However, do be careful with demotion because they do tend to be risky, because if an employer fundamentally alters the employee's job duties, its work condition, the employee could argue that he was constructively dismissed. You can also build a case that termination for cause is warranted in certain cases, or even in a non-unionized setting, an employer can simply decide that it is not worth the time and energy to bring the employee performance up to speed and in line with expected standards. And in that situation, an employer may simply elect to terminate the employee without cause and offer a severance package in exchange for release. So we will now talk about performance improvement plan. So poor performance shouldn't be ignored and shouldn't be condoned. An appropriate way to manage poor performance may be through a performance improvement plan. This plan is intended to put the employee on notice that their job performance is not meeting expectations and that the employee requires improvement. It is generally implanted once the employee has been informed of issues of performance at least on one or more occasions in the past. And the performance improvement plan puts also an employee on notice that if they do not show sustained improvement over a reasonable period of time, they could be subject to discipline up to and including termination. The plan should be fair. The employee must be advised of the specific areas of concern and where his performance is lacking and where he requires improvement. The plan should also specify the objective that the employee must meet in an effort to improve performance. They should be given specific tasks with specific deadlines. And the plan should also include a period for completion for meeting the required performance objective. So basically, the employee shouldn't be left on his own devices with the plan. There should be regular communication with him, with the employee during the period that is given to him. We just want to ensure that there is adequate training and that assistance and support is available to the employee. And don't hesitate to ask your employees what they think they need to improve. Maybe they even have some ideas. On this slide, we provided you with an example of what a performance improvement plan can look like. So as you can see on your screen, we can find a period of time that the plan is applicable. We see the concern of the employer and the expectations. It also needs to be clear to the employee that if his performance continues to be deficient, he will be subject to disciplinary measures up to and including dismissal. We don't want the employee to be surprised at the end of the process if that is the conclusion and that is what happens. One tip that we have for you is that the employer should have the employee sign the plan to acknowledge the decision that they have had with him, to ensure the understandings of the issues that have been addressed and simply understanding of the expectations going forward. Things to avoid. So avoid setting up unrealistic expectations. For example, setting up expectations that were not part of the employee job duty before. It should be expectations that can be met within the time frame provided. Also, do avoid increasing targets. You shouldn't be making it harder on the employee to meet expectation. For example, an employee who had a 70% target and afterwards we put it on a 90% target. Do avoid that. Also, avoid discussing or planning further progressive discipline before the evaluation date. So after the plan is in place, you should avoid discussing discipline with the employee in the time period that you gave to him to improve. Give him the time to improve and you can discuss it when the plan is completed or done. Next slide, please. So we will briefly discuss a case where the Ontario Court of Appeals said, no, this plan was not valid. And the employee worked for the employer as a store manager at one of its franchise restaurants, and the employee consistently received positive performance review for 20 years. And then 1 year, she received a negative review. And this negative review came as a shock to the employee. As I just mentioned, she had 20 years of positive reviews, and she had not received any indication that her performance was lacking beforehand. And rather than imposing a performance improvement plan at her own store, the employee transferred the employee at another store at a failing restaurant, a poorly performing restaurant, and put her on a 90-day plan. As I mentioned, the employer also increased the target that she had to meet. Ultimately, she didn't meet those targets, and the employer announced to her that she would be demoted to a first assistant role. The employee refused to accept the demotion, and she was terminated by the employer for cause. And she later on brought up an action for wrongful dismissal. The Court of Appeal found that the employer's discipline in this case basically set up the employee to fail. She was transferred to a poorly performing restaurant, expected to turn it around and perform beyond the standard that she had been expected to meet in the past. And as a result, the Court of Appeal found that the employee was consecutively dismissed.
All right, so thanks so much for that, Amélya. What I'm going to do now is talk a little bit about progressive discipline, which in itself is its own performance management tool. Next slide, please. What is progressive discipline? It's a process by which an employer imposes disciplinary measures of increasing severity to correct employee misconduct. And importantly, it is a performance management tool, and it's a performance management motivation tool. At the end of the day, much like performance improvement plans, progressive discipline is another tool in your tool belt as a manager or as an HR professional to hopefully motivate an employee to correct or improve their behavior so that they're not having to receive ever escalating forms of discipline to the point of termination. Next slide, please. The purpose and the importance of progressive discipline, I really think, cannot be understated. I think that likely all three of us, Amélya, Nicole, and I, have received calls from clients where the direction is, or the request is, whether we can terminate employment. That something has happened, we're provided with a description, and based on that description, the question is, can we terminate? And many times that request is based in part on built-up conduct over many, many months and sometimes years that's caused the employer frustration, but which the employer didn't formally discipline the employee for. And so it builds up until you can take it no more, and then you want to terminate. And unfortunately, we often have to deliver the news that certainly termination without cause is not possible because of a failure to follow a program of progressive discipline. Progressive discipline has been approved by both courts, obviously, and human rights tribunals for non-unionized employees, and arbitrators for unionized employees. And again, the purpose of progressive discipline is multiple-fold. Fairness for both the employee and the company, an opportunity to change negative behavior, an opportunity for the employer to reinforce their expectations, policies, and work rules, It may be a situation where, for example, you hire an employee and they sign the acceptance of a handbook once they receive it, and then they never look at it again. And so progressive discipline, if carried out properly, gives an opportunity to reinforce those expectations, to revisit, and to refresh and refamiliarize the individual with those rules. Progressive discipline offers management support. Again, you're taking steps to discipline this individual, and if corrective action doesn't take place to a sufficient extent, it may result in termination. Avoidance of potential legal claims. In both a non-unionized context, but certainly and critically in a unionized setting, progressive discipline is critical to ultimately establishing a case for discharge for cause. And again, we know that in the unionized setting, that a without cause termination is not possible. The protections that unions offer with respect to terminations are critical. And progressive discipline, again, absent a single overriding offense, and these can be single-time offenses involving very serious conduct, assault, sexual assault, theft, fraud, may on its own be misconduct that's supportive of discharge for cause. But in most cases, progressive discipline is necessary. And so to either avoid a legal claim or to build a defense against a legal claim, progressive discipline is critical. Creating a written record. Progressive discipline forces you to create a written record. And I can tell you that sort of as legal counsel who may be called on to defend you in a wrongful dismissal case or in a grievance arbitration involving discharge, having that written record of outlining the conduct or misconduct that's occurred, the corrective action that's been applied is important in that it demonstrates that the employer has taken steps to attempt to correct behavior. The employee is not going to be able to say, listen, I had no idea that what I was doing was wrong, or boy, I was totally blown over when I received this termination letter. Again, it provides an opportunity to fix things and hopefully avoid the possibility of termination, because termination of employment, it not only results in again, upset for the employee and the employer, loss of income from the employee, but costs for the employer in many respects, recruiting, training, rehiring, and of course, with respect to a wrongful dismissal claim or grievance arbitration, the payment of any termination payments or on a voluntary basis or subject to an award by an arbitrator or a court. Next slide, please. There's various stages of progressive discipline, and everyone has a progressive discipline policy that's a little bit different. This is just highlights some of the sample stages that you would have in a policy. You could, prior to the verbal warning, include a counseling or a coaching note, but typically you move from a verbal warning. That verbal warning should be, even though it's verbal, it should be documented in writing that it's been provided. That moves next to a written warning or written notice, and then a suspension or a series of suspensions without pay. I put a note there that, with suspensions without pay is a unionized context, the only one where suspensions without pay are feasible. There is some case law in the non-unionized setting that says that a suspension without pay constitutes a constructive dismissal. Other courts have said, again, if you're going to terminate for cause, termination for cause is the capital punishment of employment law, you should be doing everything short of termination before actually terminating. What's important about at any stage of the progressive discipline is setting out the detail of the infraction, the expectations in terms of corrective action, and then critically, the consequences of a failure to correct behavior and of reoffending. And what I often come across, and I know my colleagues have as well, is some employers will be shy about that penultimate sentence in a written warning or a suspension letter where they say, further misconduct or further policy violations will or may result in further discipline up to and including termination for cause. Well, certainly if you reach the point of a 5-day or a 10-day suspension, a situation that you believe is a final warning prior to termination for cause, then you need to articulate that in the written document as well. You need to be bold and clear for the employee. Any further misconduct or policy violations will result in termination of your employment for cause. So it cannot be argued that the employee was not aware of the consequences of a further offense. Next slide, please. Talk a little bit about conduct that warrants progressive discipline. Next slide, please. Obviously, the onus of proof in discipline cases is, of course, always on the employer who is wishing to impose the discipline. And that's something to remember, that ultimately discipline for behavior shouldn't be a fait accompli. It's not necessarily always obvious either that discipline is warranted or that a decision to discipline will be upheld by an arbitrator. The burden is on the employer to establish that discipline is warranted. It's a civil onus that's on a balance of probabilities, but importantly, where the misconduct constitutes criminal or quasi-criminal activity, if you're alleging fraud or theft or assault in some cases, the standard will be closer to a criminal one, clear and convincing evidence. Next slide, please. Adjudicator is going to ask two key questions. Do the facts warrant the implementation of discipline? And if so, is the specific penalty imposed just in all circumstances? And again, this perhaps won't be a surprise to you, but certainly at Canadian law, the threshold for a termination for cause, whether it be in the unionized or a non-unionized setting, is extremely high. Next slide, please. When you're considering applying discipline, and this can be at any stage of the progressive discipline process, up to and including termination, it's important that you consider whether there are any aggravating or mitigating factors at play. It'd be nice to avoid them, to just look at what happened and apply discipline based on that. But the reality is that an adjudicator is not going to do that. They are not going to look at the conduct in a vacuum. And they will look at aggravating or mitigating factors in determining whether discipline is just. And so you should too. Aggravating factors in some cases can be the manner in which you have managed in the past, whether your practice in terms of enforcing policies is strict or it's lax, if the violation is a critical one or non-critical, the disciplinary record of the individual. It's relevant, certainly, in a non-unionized employment setting. It's critically important in a unionized employment setting where you may have A sunset clause that after 12 or 24 months means that discipline on file is no longer relevant in terms of the consideration for future discipline. Whether or not the violation is premeditated or if it's a heat of the moment offense, the admission or the absence of an admission or remorse or apology for the conduct. That's often critically important in terms of being the decision-making factor between a decision to terminate and some lesser form of discipline. Ultimately, an adjudicator is going to ask the question, has the relationship of trust truly been irreparably breached with this employer? And a failure to admit one's conduct, to express remorse, to commit to do better, that can tip the scales in terms of an arbitrator finding, look, no, this relationship is irreparably broken, and to support a decision to terminate. And then finally, the manner in which an investigation is conducted. Hopefully, any investigation that you engage in is one that's without bias and done in good faith. Next slide, please. Again, there's no one-size-fits-all approach to discipline, and again, each set of fact circumstances are going to be different. But just to got a couple examples here. If we have a progressive discipline program that starts from informal coaching through to termination, starting up with fact pattern 1, Larry misses a day of work and does not call in to explain. If that's never happened before, it may simply be a coaching that's warranted, explaining why it's important to call in before, to call in if you're sick, if there's a justification for it, and to note that, look, this is a coaching session, but any future occurrences may result in formal discipline. Fact situation number 2, Greg corners Martha in the hallway and purposefully brushes against her inappropriately. Now, we don't know whether Greg has done this before. We don't know his length of service. We don't know his disciplinary history or whether or not he's received training on respect in the workplace recently. But this is a serious violation. It appears to be intentional and certainly could give rise to a suspension and potentially termination if Greg doesn't recognize that what he has done is inappropriate, if he doesn't acknowledge it, if he doesn't express remorse and commit to not doing it again. Fact situation number 3, Lucinda makes the same reporting error 3 times and has been coached about the same problem twice already. So she's been provided with informal coaching to date, but continued to make the error. Likely the most appropriate discipline here would be to move to a written warning. Should you start at verbal? Possible, but the reality is that coaching's taken place twice. I think that it's supportive enough to move to a written warning. And again, in that written warning, ensuring that you make clear that further incidents like this will result in further discipline up to and including termination for cause. With that, I'll turn it over to Nicole to talk about when and how to implement progressive discipline.
Thank you, Matt. So Matt's obviously taking us through progressive discipline. I am now going to talk a little bit more about when and how to implement that progressive discipline. So before you implement progressive discipline, as the employer, you should ensure that you establish objectively reasonable standards of workplace conduct. So how do you do that? Well, first, you need to make sure that you've created reasonable workplace standards of conduct. So you have to establish what those standards are. You also have to ensure that you communicate those standards to your employees. An employee cannot follow a standard that's never been communicated to them. Another important step is training your employees on those standards. So not only communicating it to them, but ensuring that you've trained them on how to meet those standards. And then finally, supervising employees. So ensuring that you have employees, you communicate to the employees, you've trained the employees on these standards, and now you've also supervised the employees on these standards to ensure compliance. Of course, it goes without saying that last bullet on the slide there, employees should not be disciplined for failing to follow rules that were never established or communicating to them. If you go down that path, you are going to be looking at a discipline that's likely not warranted in the circumstances. Now, some rules are so obvious that you don't really need to explain them. So Matt's given us several examples throughout his slides there about, theft and fraud and stealing. So those are pretty obvious. Don't do that in the workplace. But there are other standards of conduct or performance that may require specific or particular attention because of the industry or the type of workplace. So for example, specific or certain types of safe work practices and particularly safety sensitive workplaces, those may need to be set out in more detail and communicated to employees so that they properly understand the standards that they're expected to meet. So where do you set out these standards? Well, there's a number of places where you can set them out. The most obvious ones are your employee handbook, your workplace policies, and then of course through training. So in addition to policies covering particular subjects which may give rise to progressive discipline, so that can include things like attendance, conflicts of interest, harassment, discrimination, workplace violence. So in addition to the policies covering those types of things, some employers also have formal progressive discipline policies. Next slide, please. So what exactly is a disciplinary policy? Well, essentially, a disciplinary policy advises employees of the consequences of misconduct and what will happen if they engage in repeated forms of misconduct, but it also provides supervisors with guidance on how to carry out discipline. So it provides a mechanism for greater consistency and enforcement of workplace rules, but it also reduces the risk of employees claiming that they've been discriminated against or being treated unfairly, that they've been targeted or picked on, because it's actually following a set out mechanism through which discipline will be dealt with. Now, many employers create separate disciplinary policies and then incorporate some of those terms throughout their other workplace policies. There's no one size fits all, and there's no particular format for a disciplinary policy, but there are some key things that should be included in any disciplinary policy. So first off, as my colleagues have said throughout the presentation, the whole purpose of this disciplinary policy should not be punitive. It should be rehabilitative in nature. So the whole intent of it is to ensure that you provide warnings and opportunities for employees to correct behavior, to conform to your standards, and to meet those expectations. In the disciplinary policy, you should ensure that it is progressive in terms of severity. So typically less severe forms of discipline for less severe forms of misconduct, and conversely, more severe forms of discipline for more severe forms of misconduct. So for example, an employer's disciplinary policy may allow for informal discussions, as Matt had said earlier, coaching, for example, followed by verbal and written warnings, and then ending with termination for cause. You want to ensure that your discipline policy is flexible. So it should include permissive rather than mandatory language. And this really allows the employer the discretion and flexibility to skip or repeat steps in the disciplinary process. So when you have that more flexible language, you're not held, your hands are not tied to following a certain process. So you must do coaching, followed by you must do verbal warnings, followed by written warnings. But it allows you the flexibility where there is a particularly egregious form of misconduct to go straight to discipline of suspension, or even further, to right to determination. So you want to have that flexibility baked into your discipline policy. And then of course you want to, again, with that flexibility, preserve the ability to dismiss for just cause, even where there's a single incident of serious and significant misconduct. So an example there is if you're in a safety sensitive environment, a safety sensitive violation or a loss of a license due to misconduct or theft. Those are certain types of more egregious forms of misconduct that you want the flexibility within your disciplinary policy to allow you to terminate, even if there's only been a single incident of that misconduct. Now, some forms of discipline are not generally permitted. Matt has talked a little bit about that with suspensions, and Amélya talked about demotions. Now, the exception there is if you have authority to use those forms of discipline because that authority originates in an employment agreement or a collective agreement, for example. But in the normal course, if you don't have that authority in those documents, engaging in an unpaid suspension or a demotion can result in a constructive dismissal. So you want to be careful on the type of discipline you impose. Now, a discipline policy should also summarize the process for investigating misconduct and issuing discipline. So an employee is not actually entitled to a formal investigation prior to being disciplined, unless, of course, that obligation originates in a policy or in a collective agreement provision. But in most cases, it is certainly advisable to do an investigation so that whatever determination you arrive at, whether that's suspension or that's just cause termination, you have done your due diligence to ensure that you can support that decision. The other important piece about investigating the misconduct is that it allows for procedural fairness. So you give the employee the opportunity to respond to the allegations and to provide their kind of defense to why they engage in a particular form of misconduct. Now, in unionized settings, an arbitrator can actually set aside the discipline if the unionized employee was not provided with that opportunity for union assistance during the investigation and disciplinary process. So if you are in a unionized setting and you do engage in that investigation, it's very important that you look at your collective agreement to verify whether there's any union representation rights that you need to afford the employee. Next slide, please. So you're in a situation where you've identified misconduct and now you're left with the question of, well, now what? What do I do? So before resorting to discipline, there's a number of questions you need to ask. One, have you done that proper investigation? So have you done your due diligence to assure yourself that, next bullet, accurate facts, that you know what the facts are, that you're not acting on speculation, you're not guessing as to what happened, but you actually have done your investigation and you know what the facts are in the situation. Importantly, not only do you know what happened, but can you prove it? And those are two different things. It's great that you might know something happened, but if you're going to act on it to discipline an employee, you need to make sure that you can prove it, particularly if you're going to be moving forward with a for-cause termination. And if the person commences litigation, certainly you're going to need to have the ability to prove why you disciplined this employee. Now, the next bullet there, has the employee been given an opportunity to explain? Now, that's important, and that would come up in your investigation. So if you've investigated the misconduct and you've met with the employee, that's your opportunity to understand, are there any mitigating factors here? So are there any factors here that make this person less culpable? So for example, if they've disclosed to you that they're dealing with a disability that has impacted their behavior in the office, that might be a mitigating factor that may suggest that going down that progressive discipline to something more severe is not appropriate in the circumstances. Another important consideration is, are you acting consistently with past practice? Now, if this employee has engaged in a certain form of misconduct, that this has happened before in the workplace and you've only coached people before, you've only given them a verbal warning, but this employee, you actually are terminating their employment, you're going to have an issue. You're going to have a claim probably against you, or a grievance, where the employee claims that you've condoned this behavior in the past and you've targeted me for this behavior, whereas other people got a slap on the wrist. You don't want to find yourself in that position. So you do need to take that misconduct and look at it in the context of the history of employees and have others engaged in this behavior before, and what disciplinary action did you take in those other circumstances. And then finally, are you timely? So that can go both ways. You don't want to act in a hurried manner. And I know that sometimes that's the inclination, is this person has engaged in serious misconduct and the inclination is fire them right away. You need to be careful though, and you need to slow down and first think, well, okay, we know this happened, but again, that third bullet, can you prove it? And usually you need the investigation, you need to conduct one in order to be able to assure yourself and assure an adjudicator, if you get there, that you can prove this misconduct. So don't act in a hurried manner. Take your time, make sure that you have all the facts before you act. But the flip side of that is don't take too long. So you don't want to delay an investigation and drag the matter out, because then the employee may take the position that you didn't think the misconduct was serious enough to terminate their employment for cause, which is why you've allowed them to remain employed. So you need to, it's a delicate balance of don't act too hurried, but also don't take too long. Next slide, please. So we thought it would be helpful to provide an example of the consequence of failure to investigate. And this happens quite often, particularly when you're in face of pretty egregious misconduct. There is the inclination to just act right away and terminate for cause, but without doing an investigation. But there are potential consequences for failing to investigate. So one example of that is this decision on the slide here, Kerr versus RPAC. And there, the employer gave its 70-year-old occupational health and safety manager 1 year's working notice that his employment would be terminated. Now, this manager had almost 23 years of service and had a clean disciplinary record, no prior discipline. He was diagnosed with reactive depression after he received the notice of his termination. And he gave the company a doctor's note stating that he wasn't fit to attend work during that working notice period or for a portion of it. Now, while he was off from work, he explained because he was so distraught because he was being terminated, he altered a spreadsheet to make it inaccurate. And he also deleted hundreds of business and personal emails from his work email account. Now, after being confronted by the company, the manager apologized through his lawyer. So he had retained a lawyer. The lawyer wrote to the company on his behalf and apologized. And his lawyer justified, or at least tried to justify, the manager's actions by saying that he was clearing his computer of personal data and offered to have the manager repair the damage himself. So send me the document, I will fix it for you. Or alternatively, they offered up the solution of having him show another employee how to fix the document that he altered. Now, the employer didn't conduct an investigation here. They determined that the extent of damage was significant, and so they went ahead and terminated his employment, concluding that there was a breach of trust and that this amounted to just cause for termination. So they went ahead and fired this OHS, Occupational Health and Safety Manager. Now, the BC Supreme Court found that there was cause for discipline, but not just cause for termination. So again, you're always going to have those two questions. Do you have justifiable reasons to discipline? If yes, do you have justifiable reasons for cause for termination? Two different questions. So the adjudicator here said there was no just cause for termination. And in finding that, the court noted that termination or just cause termination is the most serious form of discipline. And each case has to be considered individually to determine if it's appropriate discipline in that particular situation. Now, the court found that the company here failed to consider mitigating factors or to consider less serious forms of discipline. Now, there are a number of mitigating factors that the court found existed here that notably the employer could have discovered on their own had they done an investigation. So some of those mitigating factors included the lack of harm caused. So they said, yes, the court found that, really bad that this person deleted or altered this document, but there was no actual harm that resulted from him having done so. The court also found that there was a failure to properly consider his medical condition. So the employee here said after he was terminated and given the working notice, he suffered some medical condition that I guess altered his behavior or put him in a state of depression that caused him to engage in this behavior. So the court said that the employer failed to consider this. The court also found that the employer failed to properly consider his long record, which was clear of any prior discipline. And then finally, the court noted that the company failed to investigate the matter. So here, that failure to investigate ultimately resulted in this employee being awarded $112,000 in damages. So quite a hefty price tag for failing to do what honestly is a pretty easy step, investigating to ensure that you have evidence that you can stand on to support your decision. So what can we take away from this decision? Well, the failure to conduct a proper investigation can certainly undermine your case for termination for cause. So you should always, even if it's a very egregious form of misconduct, you should always do an investigation to ensure that you have evidence that supports your decision. And again, you should always ask yourself the same two questions that the adjudicator asked here. One, is there cause for discipline? And two, if yes, well, is it a suitable level of discipline, whatever level of discipline you've chosen? And then finally, making sure that you are also considering, just as the adjudicator has, both mitigating and aggravating factors. Next slide, please. So what does investigating the misconduct look like? Well, so you have first, you've learned of the misconduct. The next step is to plan and then plan some more and then plan some more. So you got to do a lot of planning. So first off, you want to consider things like, was this misconduct on duty or off duty? Did it happen on our property, off our property? Is it criminal in nature? So does it involve assault, for example? Are there human rights issues involved? So just like the last case we talked about, there was a human rights consideration. This person was suffering from a mental condition, a medical condition. So you need to take that into account. How's that going to impact the level of discipline that you issue here? Were there others involved? Were there witnesses? You need to speak to those individuals if it's helpful to understanding what happened, what took place. What policies are engaged? Is it your harassment policy? Is it a violence in the workplace policy? You need to identify what standards, again, going back to the standards that you've established, what standards here have been breached. You also want to consider confidentiality concerns. So who needs to know about this misconduct, who needs to be interviewed, and when you're interviewing folks, making sure that you ensure that they understand the importance of confidentiality and not disclosing the matter to others. So you conduct the investigation, you gather the facts, and the other important consideration before you actually conduct the investigation is to determine, is it appropriate for you to do this investigation? Is there potential bias, or could it be perceived as bias if you're internally doing the investigation? Do you need an expert in a certain, if for example, if it involves the allegations of race, do you need somebody who has, a particular EDI training to come in to do this investigation? So you want to consider whether you're doing this investigation internally, or if you're going to have it farmed out to an internal investigator. And then ultimately you make your decision. Next slide, please. So I won't go through this slide in much detail, other than to say that you need to consider, as part of your investigation, what documents or other types of means you need to gather information. So for documents, are you going to need personnel files? Are you going to need electronic files, work files, medical files? Other means is, are you going to have to search property, a desk, a locker? Are you going to have to administer drug or alcohol tests in order to assist with your investigation? So those are all things that you need to consider. Next slide, please. So again, at this point, you've probably heard all of us say this many, many times, but first determine whether to discipline and at what level. Then you need to explain to the employee your position as to why you've selected that level of discipline. And then you want to, again, make sure that you can defend that position to an adjudicator. Next slide, please. So again, just some highlights here of determining the appropriate discipline. We've said this before, but discipline should be corrective rather than punitive. And at a minimum, progressive discipline should advise the employee of the specifics of their misconduct. So they shouldn't be left wondering, what did I do wrong here, as Matt had said earlier. You should advise the employee what is needed to improve. So they shouldn't be guessing on, how do I correct this behavior? It should be clear and spelled out for them. You should provide the employee with an opportunity to improve and meet expectations, and also consider offering assistance in meeting those expectations. So training, for example. Now, if performance is not improving, then you need to make sure to warn of specific consequences if the substandard performance persists. So determining the appropriate discipline, that's always the toughest part of the entire process. How do you know which form of discipline to go with? So to highlight an example of determining that appropriate discipline, I'm going to discuss this case here. And it involved an employer that was a vehicle dealership, and the employee had worked there since 1984. So long time. The case was, this employee had a long service. Now, his latest position, the employee's latest position before he was dismissed, was service advisor. And the employee was known to have used his personal cell phone to take photos of customers and had received warnings about this conduct before. Now, a female customer was being assisted by someone else at this dealership, and the employee took a video of the customer using his work supply tablet and another video using his own personal cell phone. He did this without the individual, the customer's knowledge or consent. The employee later shared the video with coworkers as a form of entertainment, and later justified making the video on the basis that the employer had security camera footage in the dealership. So what was the big deal of him taking this video? Now, the employer terminated this employee, and the employee then brought an action against the employer for, among other things, damages for wrongful dismissal. The employer brought a motion for summary judgment motion, and that motion was actually granted. So the court found that the employer established just cause for the employee's dismissal for a number of reasons. Now, the court said that the video had been taken for improper non-work related purposes of mocking this particular customer and ridiculing her appearance. The court also found that as a senior employee, the employee would be expected to show leadership to younger, less experienced employees, and the employer had placed in him a high degree of trust. So again, that's an aggravating factor here. The court found that no customer had any expectation that they would be filmed at close range without consent. And the court found that if this conduct had become public knowledge, that it could actually significantly damage the employer's reputation. Now, the court noted that while the duration of the misconduct was short, so these were short videos that the employee had taken, again, they found that the employee's misconduct really struck at the very heart of the employment relationship when considering the whole circumstance and context. And so for that reason, they found that there was a breakdown in the relationship and that the employer here had just cause to terminate the employee's employment. Okay, next slide, please. So I'm going to probably go a little bit faster because I think we're getting short on time here, but this slide here, how to communicate effectively when issuing discipline. Avoid the sandwich approach, be clear, don't sandwich it in by positive feedback, just be direct and clear about the issues at hand. Make sure that you clearly spell out the problem, define the solution and expectations, and make sure that the employee understands that future instances will result in discipline up to and including termination, and offer assistance. Next slide, please. Now, importantly, you want to make sure that you keep a written record of basically everything. So your performance reviews, your attendance records for training sessions, receipts and acknowledgement of policies, warnings, counseling, disciplinary measures imposed. You want to keep a record of everything because you want to make sure that if you have to prove or support your decision that you have a record of the reason of the decisions you took and all the reasons that you took it. So next slide, please. So there are some circumstances where progressive discipline may not be warranted. So next slide. Yep. So progressive discipline is not always appropriate. Think of serious misconduct. So things again like theft, sexual assault, violence in the workplace. Those are instances where you may not need to implement progressive discipline, or where it's involving a senior level manager. So it's expected that they know that they should be following expectations as leaders within the organization, and also in situations of zero tolerance. So think, for example, alcohol or use of alcohol and drugs in the workplace, particularly in a safety sensitive environment. So I think I will probably stop here because I think we might run low on time, but suffice to say that termination for cause has been viewed as a capital punishment of employment law. So it needs to be viewed more as the exception as opposed to the rule. And you want to make sure that if you are going to move forward with a termination for cause, that you have very, very good basis, very, very good proof of why that was appropriate in the circumstances. So we were going to go through another case, but I'm going to maybe stop there. And hand it back over, I believe, to Matt.
Matt, yeah, okay. We can move on. Thanks very much, Nicole. We can move forward then to some non-disciplinary strategies for addressing poor performance. Again, you are going to have some situations where discipline may not be appropriate, and just very quickly, just highlighting a couple of them. Again, depending on what the individual's issue is, providing a flexible work arrangement is something that may help address that individual's issues if they've got punctuality, attendance issues, particularly if they are related to some sort of human rights protected ground. Obviously, management support and coaching is critical. Training and education. It's not sufficient, I would say, that, for example, that any training with respect to, proper workplace conduct and avoidance of misconduct only takes place at the point of hire, and you leave it at that. Regular training and education is critical. Sometimes employees can be incentivized, and that can be by way of a variable compensation. Obviously, leading by example. As a supervisor or a manager, walking the walk and talking the talk is critically important. Next slide, please. Any sort of manner in which employees can be empowered, right, to take control of their work performance, compliments, bonuses, obviously compensation, and other forms of remuneration. And then for those individuals who are struggling, the availability of an employee assistance program. And I think with that, what we'll do is we'll just go right to Amélya and considerations for Quebec employers.
Thank you, Matt. So perhaps some of you that are currently attending the presentation also have employees in Quebec. Maybe you are considering hiring employees in Quebec and are covered by provincial employment legislation. If so, it's important for you to bear in mind some particular and some specific for Quebec employers. So unlike the other provinces in Canada, Quebec is a civil law province. As such, common law is not applicable in Quebec. This does not necessarily mean that everything that is done in the employment and labor law in other provinces are not applicable in Quebec. For instance, everything we've just discussed, performance management, progressive discipline, those remain applicable in Quebec. Next slide, please. We are now going to discuss the termination of an employee working in Quebec. For unionized employee, it's similar to the common law provinces, so I won't go into the details here. But in the event of a termination, the employee may file a grievance against his termination and with his union. For non-unionized employees, several recourses are available to them in the event of their termination. We will discuss about two recourses in particular, so the ones that you are seeing on this slide. The recourse against a dismissal made without good and sufficient cause under the Act Respecting Labor Standard, and the civil action for a reasonable notice period under the Civil Code of Quebec. In addition to these recourses that I'll cover, I'd like to add and point out that there are other recourses available to non-unionized employees in Quebec. We can think about, for example, a complaint for a prohibited practice. So that is when an employer imposes a disciplinary measure or a reprisal measure on an employee because he exercised a right provided in the Quebec Act Respecting Labor Standards. We can think about human rights recourses also under the Charter of Human Rights and Freedom. But we're going to focus on this in this presentation on the two I've just mentioned to you. Next slide, please. As I mentioned, under the Act Respecting Labor Standards, there is a recourse that is available to employees who are dismissed and who consider that they have been dismissed without cause, without good and sufficient cause. So this recourse is available to employee credited with 2 years of service with the same employer. It is, however, not available to senior management. With this exception, the hack really targets the highest ranking employees in the business. So for example, a simple supervisor would likely not be covered by this exception and could file a complaint. However, we can think about, for example, a president or vice president of a company that would likely be covered by this exception and cannot and would not have access to this complaint. I would say that in practice and in my experience, this recourse against a dismissal made without good and sufficient cause comes often as a surprise to some of our clients who are based outside of Quebec, but who employ people in Quebec, because essentially this complaint prevents a Quebec employer from terminating without good and sufficient cause an employee who has at least 2 years of service with the same employer. So while it is always important to manage your employees' performance and impose progressive discipline when warranted, it's even more important to do so in Quebec when your non-unionized employees have at least 2 years of service. Because if you decide to terminate the employee without cause and, for example, offer him a severance package, as we discussed, maybe you don't want to enter into a process of performance management. Well, if you terminate the employee without cause, offer him a severance package and in exchange for a release, the employee could simply the employee can simply refuse and file a complaint instead. And what is important to note is that the employee making such a complaint is represented free of charge by a lawyer from the CNECC, which is the agency that oversees the application of the employment standards in Quebec. So on the next slide, what you can see is what the employee could obtain if his complaint is upheld. So the tribunal can order the reinstatement of the employee in his job. This is always the first option that the tribunal will look at. However, if reinstatement is impossible, for example, the position was abolished after the termination, the tribunal will generally award an indemnity for loss of employment. This is usually equivalent to paying a few weeks of salary for each year of service, and we are normally looking at 2 to 4 weeks per year of service. However, as you can imagine, every situation is different, so it could be more, it could be less. And the tribunal will also order the payment of back pay, so retroactive wages, up to the date of the termination to put the employee back in a position as if he had never been terminated. Obviously, any salary that the employee earns somewhere else in the meantime will be deducted from that. And This compensation for lost wages can be very costly since it can take a very long time to obtain a decision from the Administrative Labor Tribunal in Quebec. I can give you an example that in Montreal, we are generally right now looking maybe between 12 to 18 months before a decision is rendered following a complaint. So sometimes the back pay can be quite costly on employers. And finally, the employer can always award moral or punitive damages depending on the facts of the case. Next slide, please. Another recourse that is available to non-unionized employees is civil action before the courts to claim a reasonable notice period. So this recourse is either brought up before the Court of Quebec or the Superior Court, depending on the amount at stake. And in Quebec, when an employer terminates an employee employment without serious reason, he must give the employee a reasonable notice of termination that can be given in time or in money. And unlike the claims filed with the CNSST, the employee who chooses this avenue, this path, must assume the cost of his legal representation if he hires a lawyer. And you may be wondering, well, why would an employee choose this path rather than filing a complaint with the CNSST? Well, I can tell you that in the vast majority of cases, employees will definitely turn towards the CNSST and towards the CNSST complaint, the one we've just discussed. However, as I mentioned, senior management don't have access to the other complaints, so we will often see them taking this path instead and turning to the civil action. And sometimes, too, we will see certain employee who will turn to this avenue rather than going with the CNSST complaint simply because they have not respected the deadline for filing their complaint with the CNSST because they have 45 days from their dismissal to do so, whereas this civil action can be brought within 3 years of the termination. Next slide, please. So briefly, what is a reasonable notice period? It will be determined according to a bunch of different factors that you can see on your screen. So the nature of the employment, the duration of the employment, the age of the employee. Generally, once the threshold of 50 years old is reached, the courts will tend to increase the compensation awarded. The courts will also look at the salary and any other specific circumstances. For example, was the employee enticed away by the employer from a stable job? And we will normally look at reasonable notice of termination that varies between 0 to 24 months. We discussed earlier that sometimes an employer doesn't want to enter into a performance management or progressive discipline process and will instead take the option of terminating the employment without cause and offering a severance package in exchange for a release. As we've just discussed, in Quebec, you need to be careful with this option when your employee has more than 2 years of service. However, another warning I wanted to give to you today is that we often see employers who have employment agreement that specify in advance what the employee would be entitled to in the event of termination without cause. So for example, we often see that the agreement will specify that the employee will be entitled to the minimum required by employment standards and maybe an additional 5 weeks, 10 weeks in exchange for a release. While this option may work in other Canadian provinces, in Quebec, it is not possible to contractually limit in advance the severance package that an employee may receive in the event of termination without cause. So it is prohibited by the Civil Code of Quebec. So any clause in an employment contract that limits the employee's right to reasonable notice period would not be enforceable in favor of the employer. However, it becomes a minimum to which the employer commits to the employee. So the employee would at least be entitled to what is provided for in the contract, but this does not necessarily constitute a maximum. The employee could always seek further compensation through the civil courts if he didn't sign a release and thinks he could be entitled to more. And finally, my last consideration for you that I wanted to talk to you for Quebec, evidently, as you can notice, French is our first language. So I wanted to talk to you about the Charter of the French language. So today we've talked about setting up policies, for example, for progressive discipline and having your employees maybe sign releases. So I just wanted to mention that in Quebec, employers now have more extensive obligation when it comes to the French language. As such, contracts with employees whose main terms are not negotiated must at least be in French. We can think about employment agreements, release, for example, for low-level or mid-level employees, where the employer will simply impose the release, the terms of the release on the employee, and there is no negotiation there. And in Quebec now, an employee cannot agree to be bound by the English version of a contract if he didn't get the opportunity to consult the French version first before signing. So this means that before signing, what we recommend is that the employer present the French version of the contract, of the agreement, of the release to the employee before he signs the English version. And moreover, company policies must also be available in French. And I will now turn it over to Matt, who will talk about our last subject of the presentation regarding remote and hybrid work environments.
Terrific. Thanks, Amélya. So we'll just wrap things up with a quick discussion of performance management in the remote and hybrid work environment before we get to a couple of questions. I think the important thing to note here is, this is an evolving area of the law. It's a moving target. It was not the new normal prior to the pandemic, which is why it's the new normal now. But I think, again, critically, what COVID has shown us, and now coming out of COVID, is that, look, there has been a sea change. The old position of we can't accommodate you working from home is no longer the practical or even the legal answer now and into the future. It's unfortunate for some employers that during the pandemic, again, they were legally required to allow employees to work from home, and that has worked. It's shown that remote work, if managed properly, can be highly successful, and so it really is here to stay. Next slide, please. Again, 52% of workers would prefer a more flexible working model post-pandemic. The thought perhaps was that, as we came out of Omicron and entered into the first half of 2023, that was going to change, but it really hasn't. And so employers need to be aware of that if you aren't already, and be prepared to deal with it. Next slide, please. Look, the one thing that we do know is, again, employees want the ability to work on a remote or a hybrid basis. There's no consensus yet in terms of the optimal balance between work days at home and work days in the office. But the one thing that we certainly are seeing is that the least experienced workers, in terms of those that could work from home but are able to work in the office as well, need to be in the office the most, or encouraged to be in the office the most, because they find that collegiality, that direct contact is important for their career development. Next slide, please. Again, remote and hybrid work, here to say almost half of employees who moved during the pandemic said remote work was a factor in that. More than half of all employees prefer some form of remote or hybrid work arrangement. Remote or hybrid work is a factor in applying for employment, and nearly 3/4 of employers will continue to allow some form of remote or hybrid work. Next slide, please. Remote or hybrid work includes a number of different arrangements, both location flexibility. You can see there's a couple of examples. They include hoteling, all the way up to ideas about flexing actual work time. And that means compressed work weeks or even job sharing. Everything is up for grabs in terms of the new workplace going forward. Next slide, please. What that means then, of course, is that post-COVID employers are having to consider, look, if you're going to allow for a hybrid model, is it without any guardrails? Or do you want to reserve the right to return employees to the office, if there is a need for that? And ultimately, if you choose to do that, is there a risk of constructive dismissal? Some situations we've had questions from employers. Well, what if we just provide this as a benefit to good performers? We can tell you that could land you in a heap of legal trouble, particularly if that ends up being tied to some form of protected ground under human rights legislation. So that's a path we suggest that you don't follow. Next slide, please. The most important thing in terms of managing employees in a remote or hybrid work environment is having the tools in place to fall back on. And that means a written remote or hybrid work policy, setting out the fact that a remote or hybrid work is not a right, but a privilege, and that the employer always retains the right and the discretion to make changes, including requiring the employee to return to the office. That should be memorialized not only in a policy, but a specific agreement executed by the employee. Something new, which we really didn't see before the pandemic, is your boilerplate or your standard template employment agreements specifically addressing remote and hybrid work. Those options, what the expectations are, and again, critically for employers, ensuring that you maintain the right to direct the employee to return to the office as your business needs require. And then if you're, of course, in Ontario, we have a written policy with respect to electronic monitoring, and that applies to all employers with 25 or more employees. Hopefully you already have one of those in place, but if you don't, you should, because it's required under the Employment Standards Act. Next slide, please. Now, performance management in sort of the remote or hybrid workplace. Again, the pandemic reemphasized the need to move away from traditional performance management. And this box here is just highlighting of some key trends that we've seen so far with respect to performance management with a workforce that is in part remote or hybrid. The key change has been that annual performance review, the one that everyone does not look forward to, that you put off having to complete, that you put off having to review with your employee. That's been replaced by frequent performance conversations that take place throughout the year. And what we've seen so far in terms of the studies on this is that it's actually far more effective in terms of managing performance. And I think it dovetails, really throughout our presentation today in terms of, not delaying the management of performance, but engaging in it and doing it frequently. Closed door versus remote tech-based conversations. Again, it's not come into my office, we need to talk. Again, it's over Zoom or another remote conference tool. And again, more frequently, more openly, continuous feedback rather than your old school formal approach. Focusing on continuous and clear communication. What we've also seen is a move from a manager to not just playing sort of the disciplinarian or authoritarian role, although that's important, to more of a mentor. And again, that is emphasized by these more frequent communications. And then move from consumer to creator. So involving the employee more so in the performance management process. Again, that is going to address the fact that, again, this is a new normal. It's not your traditional approach, and it's one that you have to adapt to. Next slide, please. Again, your keys then for remote and hybrid work arrangements and to be able to engage in proper performance management, clear written expectations regarding hours of work, availability, and accessibility. I've said this before, I'll say it again, making sure that you express that the arrangement is subject to change, modification, or discontinuance at the employer's discretion. Setting out within the policy and the agreement what the work location should be. Sure, it might be remote, it might be hybrid, it might be a nomad type situation, but you as the employer still need to know where that individual is. You still need to make sure that they have the proper IT capabilities to actually engage in the work. Setting that out both in the policy and the agreement is critical. Communicate often, verbally if possible, and then, of course, tracking performance and managing performance often and consistently without delay. And with that, I think we've just got a few minutes left for some questions, and we've got many double digits in terms of questions set up here. So we'll get through as many as we can. Nicole, maybe I'll start if I can throw this question to you. Explain the difference or help poor performers understand the difference between the right to manage them versus harassing them. I'm sure that hasn't come up for you before.
No, never. Thanks, Matt. This is a great question, and it comes up all the time. And often is actually part of comes up in the context of investigations that are possibly going to lead to termination. And so there is a distinction. So someone could be a poor performer, and they may interpret their employer's efforts to try to get them on track as harassing. So it may very well feel annoying for that employee that they're being performance managed, or they're put on a performance improvement plan, or that their employer is constantly taking issue with their performance. However, that in and of itself is not harassment. And generally what you'll see and hopefully see in your harassment policies is that caveat that an exception to harassment is performance management, direction from management that's appropriate in the circumstances. What I would say is one caution is that because someone has poor performance does not mean that there aren't also harassing elements to their managers' managing of their performance. So you have to be careful and make sure that you're not conflating the two. It very well is possible that you have a poor performer who is also being harassed. So being very careful that you're not conflating the two and addressing both appropriately.
Great. Oh, I mean, it's quite an area. That's really helpful. Yeah, and I'm sure we'll be asked that question again in the future. Amélya, here's one for you. I'd like to gain some insight on how to establish the distinction between performance and issues and concerns related to health or disability challenges. So performance issues on the one hand, concerns related to health and disability challenges on the other. Is it a simple matter of asking the employee to comment on the potential cause? Any thoughts on that?
Yeah, thank you, Matt. So the situation can be sometimes delicate on the employer side because we want to avoid the employee saying that we don't respect their privacy. However, if there is a perceived disability, you have a duty to inquire. For example, we can think about an employee who has a severe change in attitude. He was never absent and suddenly he arrives late frequently. So you have a duty to inquire. And if so, you have after that a duty to accommodate. And I also want to mention that the accommodation process contains bilateral obligation between the employer and the employee. So the employee also has an obligation to cooperate in the process, and we can expect him to expect the employee to tell the employer if he has health problems, a disability that prevents him from performing his job properly. And there's nothing preventing an employer when you're meeting with your employees about performance problems from asking them if their performance is related to a protected ground, or even so only referring them to your policy on human rights maybe, or the process of accommodation. And if your company has an accommodation policy, do not hesitate to provide it to the employee. He will maybe come forward.
Great. Okay, we've got a bunch of questions here about the difference between progressive discipline in the unionized and the non-unionized workplace, including how long disciplinary letters are valid for, and what happens if a unionized employee, for example, refuses to sign a disciplinary letter. Okay. Well, the sort of 3 or 4 minute answer is this. Look, with respect to the non-unionized workplace, progressive discipline can become stale dated. It is, and again, it's going to depend on the situation by situation basis. But I think that, you'd have difficulty, for example, convincing a court that someone had a 5-day or a 10-day suspension on file for a significant act of misconduct, but that was issued 3 or 4 years ago, and there's been no discipline since then, that discipline is still valid. I think that a court would likely find that, if they put any weight on it, it would be reduced. I think ideally what we'd want to see in a non-unionized workplace is, if you are, relying on existing progressive discipline on file, for example, to ultimately take the next step to a termination for cause, if it were in the previous 3 to 6 months, ideally. That's not to say that a period longer than that couldn't be supported, but, the more recent, the better. In a unionized environment, again, this is often set out, in the collective agreement, which will either have the steps of progressive discipline set out in the collective agreement, and if they don't, they'll certainly have language that talks about the effectiveness, or how long a discipline stays in effect on an employee file. And we call this a sunset clause. That what's important is that you read each sunset clause carefully, because some of them can be very different. Some of them can say that after 12 to 18 months, all discipline is removed from file. Others require the individual to remain discipline-free for a period of time in order for the discipline to be removed from file. That's a significant distinction. And so it's important. What I always, even if I'm dealing with a collective agreement for a client that I've reviewed dozens of times, I remember not to assume that I've remembered it correctly, and make sure to review it, because, that one little 1 or 2 word difference can make a significant difference in terms of the outcome, ultimately, in terms of your decision as to whether or not to be able to move to the next step of progressive discipline, or if you've got to start again. And so with that, I think we've gone through our allotted time and a little bit more than that. I want to thank everyone again for all the great questions that you've had. Unfortunately, we're not able to get to them all, but hopefully you've taken a lot away from the presentation today. And again, I want to thank you for joining us. I want to thank my fellow speakers, Nicole and Amélya, for your terrific insights. For those attending online, a reminder to please fill in the survey if you haven't already done so. And of course, this webinar is one of our continuing LEHR series. Our next event is going to be held in the fall. please keep an eye on your inbox for an invite for that. Our event list, of course, is growing as well. Please visit our Fasken Institute section of our website at fasken.com. And I want to thank you again on behalf of Amélya and Nicole for joining us, and wish you a great rest of the afternoon, and wish you a great summer as well.